said, I would have said, or rather greeted the gentlemen, I am afraid there are no gentlemen in my class, so I am happy to greet you, the ladies. I hope every one of you is okay and getting about your business well. Now, today I chose to use this particular media to reach out to you, especially to try to give an explanatory note on the law of contract. As you will recall, we have already introduced ourselves to the definition of the law, and we know that hotel and catering law calls upon transactions, and these transactions would require that whoever provides those very services is entitled to a payment because they have put in time, they have put in resources, or they have even delivered the product. So the beneficiary or whoever consumes these particular products or services, either they are catering services or hotel services, or the food, drinks, beverages, and the other services that we labored to try to define that are provided by whoever is engaged in the hotel or the catering services. So today, I thought it's important for me to take you through the basics of the law of contract. And I hope you agree with me that we have already understood contracts to mean or include agreements. So, and an agreement, that would mean that there are two or more people who are agreeing. In law, we don't just call them people. We choose a word called parties. Parties is a chosen word because we have artificial persons and natural persons. Natural persons are individuals like you and me who breathe in and breathe out. But artificial persons are business entities, call them companies, call them partnerships. They too enter into contracts, which means an individual can enter into a contract with a company, with a university, with a hotel, with a business or a partnership. And that partnership, or rather that business, can be a profit making or non-profit making, like you look at the examples of charity. So going back to our definition, a contract is an agreement that is made between two or among more parties which the law will enforce. So that understanding, that transaction, that agreement is supposed to be legally enforced. In other words, you will not hold to account the other person if the arrangement or understanding that you entered into is not recognized by the laws of Uganda. So if you entered into any contract, for it to be binding on you, it must be lawful, as we shall explain in the subsequent classes why legality of a contract or an agreement or a transaction is very important, especially for enforceability. So in the definition, I have talked about an agreement and I have talked about the parties who are more than one. And I have also talked about enforceability. So if you are to sufficiently define a contract, then it is an agreement that is made between two or more parties which the law will enforce. Now, what is enforceability of an agreement? An agreement is defined as every promise and every set of promises forming consideration from each other. Consideration, of course, as you will also understand subsequently, has a different definition in the law. So a promise is defined as when the person to whom the proposal is made signifies his assent thereto. The proposal is said to be accepted. So which means somebody makes a promise and the other person who listens to that promise shows interest, that is accepting to be bound by that promise or proposal. A proposal, when accepted, then becomes a promise, and an agreement is an accepted proposal. So to form an agreement, there must be a proposal or offer by one party and its acceptance by the other party. So if we can illustratively, there is an agreement, and an agreement equals offer plus acceptance. If there isn't acceptance or there isn't offer for that matter, then there is no agreement. So what is the other principle that we are going to talk about? We have already talked about a contract. We have already talked about enforceability of an agreement. Now we are going to talk about something called consensus ad idem, which means the meeting of the minds. So the parties to the agreement, as we have already explained, must have agreed about the subject matter of the agreement in the same sense and at the same time. Unless there is consensus ad idem, which is the meeting of the mind, there cannot be any contract. So now we see there is an agreement which is made between two or more parties, and it is legally enforceable, and that agreement has come into existence as a result of an agreement that there is a promise or set of promises which have been accepted, or there is a proposal which has been accepted to by the parties. So there is consensus that these two parties to the agreement have agreed to be subjected to the agreement and understand what their obligations are. So it's also important to appreciate that when you already show consent, they have offered and you have accepted, then you two parties or three parties to that agreement, then you have an obligation. And an obligation is defined as a legal tie or a legal fusion, a legal unification, which imposes upon a definite person or persons the necessity of doing or abstaining from doing a definite act or acts. It may relate to social or legal matters, but an agreement which gives rise to social obligation is not a contract. Why? Because in the contract we are talking about, there must be something called consideration, and consideration means something of value, which means if you give something of value, you who gives it, you forfeit it, you surrender it to the other person who receives it. And once your agreement was that you give something of value and the other person receives that something of value, then that particular person who has received it must also discharge with an obligation, because that's what you agreed to and that's what you accepted and that's what was in your proposal, and that's basically what we call a contract. I did not want to belabor too much, but I really wanted you to understand that in the hotel and catering business, one would give a proposal. A case in point is, I have a party, will you please supply me with drinks? And you who sells the drinks will say yes, but at this cost. So when you deliver the drinks, then the other person also pays you, and there you have had your contract. And then you have agreed or you consented that this particular person delivers so much at what cost, and when they are delivered and the payment has been done, then perhaps you'll say, bring back the crates, or bring back the plates, or bring back the chairs, or bring back of course, the point I'm trying to make is that a service has been rendered, or there was a person who requested for it and it has been rendered, then there's a payment which was agreed to, or you have agreed on the payment schedule. When do we pay? Do we pay lump sum, or we pay when you have completed all? So it is also important to also know that there are very essential elements that make a valid contract. You are also now trying to adjust to certain terms or vocabulary. That is why you had me talk about offer. And that's why you also had me talk about acceptance. If somebody accepts, how do you know that that person has accepted? He communicates to you that they have. The other principle or element which makes a good contract is the intention to create a legal relationship, because the illegality in that relationship will fail the enforcement or enforceability of that contract. Enforceability in this case means that if one has been cheated, then how do they get to force the other person who has cheated to pay? That is why you use the legal means. So the other is the lawful consideration. Lawful consideration, like I did say already, that consideration is something of value. In other words, it's a benefit or a gain, a give and take. When you give, somebody takes it. What you get back? Something of value, which is called consideration. The other is, we did talk about the parties, capacity of the parties, the competence. Are they competent to enter into, are they competent to offer that promise? Are they competent to accept that promise? Are they then competent to be bound? So the parties that enter into that contract must have the capacity to enter into that contract. And the other point is free and genuine consent. And that's why I did talk about the principle of ad idem, rather the meeting of the minds, that you agree you have not been treated unfairly. When any of the parties says, I have had a raw deal, or the other one was unfairly treated, then there wasn't the free and genuine consent. And the other aspect is that those parties must not be forced, must not be lured, coerced to enter into that contract. They must understand that contract. They must freely get into it, and that's why consent is very central. The other is, I did talk about the lawful object, that what you are contracting about is lawful. The ultimate objective or the ultimate goal is legally accepted under the laws of Uganda. Agreement not declared void, meaning that void, of course, like you remember that a void is an empty space that has nothing. So an agreement should ultimately leave the parties that entered into it all satisfied that their intention was met, their purpose was served, and they are happy. If one requested that you serve them food and they wait and you don't turn up, then you have breached the contract. In other words, you have made them aggrieved, you have disappointed them, you have dissatisfied them. And if on the other part, a person supplies the food as you need it and you consume it, and at the end of the day you say you do not have the money that you had agreed to pay within that given period of time, then you have failed the other person's business. And for that matter, you have caused that person damage. They have, in other words, in our language, suffered a loss. And sometimes those losses are irreparable. And that's why it's important to have mechanisms of enforcing these terms lawfully. So, what is offer and acceptance? There must be two parties to an agreement that when we agree, one party makes the offer and the other party accepts it. In the case of Kuri versus Misa, there was an advert which said that if anybody consumed a drug called a smoke ball, and that person who did not suffer from influenza and as a result of having consumed that drug called a smoke ball, and they are not protected from influenza, the company would pay them. So Karil was the customer who went and bought after having listened to their advert. And when she bought, she then she then suffered from influenza. And the company that had put up that advert said they don't know who she is. And the court said, no, you can make an advert to the whole world. So if you look at these billboards that are advertising all these products, whether it is soda or it is beer or it is food, if your consumer to whom you have advertised to and you didn't know where they exist, the very moment they consume your product, then you owe them a duty, or you have entered into a contract because you did make an offer and they did accept it and they did pay for the service that you provided. So it is your sole responsibility to ensure that they are not hurt by the product you have given. So there was an offer, and the offer was accepted. The court did agree and rather punished the factory, though the manufacturer of that medicine. So the point I was trying to make is that one party makes the offer and the other party accepts it. And when they accept it, then they take it up and they pay as agreed to the terms and conditions. So the terms of the offer must be definite, or must be very clear for that matter, and the acceptance of the offer must be absolute and unconditional. The acceptance must be according to the mode prescribed and must be communicated to the other offerer. As you will see in my notes that explain more than what I'm saying, is that acceptance must be communicated to. If it's not communicated, then the other person is not aware that you indeed accepted what they offered. So it is also important, because when you enter into a contract, you are intending to create a legal relationship. And this, of course, was better explained in the case of Balfour versus Balfour. But let me first give a hint. Intention to create a legal relationship. When two parties enter into an agreement, their intention must be to create a legal relationship between them. Legal in the sense that it will be only enforced through legal means. If there is no such intention on the part of the parties, there is no contract between them. Imagine if parties intended to get into a relationship which they are not calling a marriage. If spouses got into a relationship which they are not calling a marriage, then they can't then turn around at one point and say, oh, we were married, because their intention was not to create that legal relationship. So if there is no such intention on the part of the parties, there is no contract between them. Agreements of social or domestic nature do not contemplate legal relationships, such as was in the case of Balfour versus Balfour. I'm going to give you a very good example here. A husband promised to pay his wife a household allowance of 30 shilling, rather $30 every month. Later, the parties separated, and the husband failed to pay the amount. The wife sued for the allowance. It was held that agreements such as these were outside the realm of contract altogether. For instance, you are married as a couple, and you promise your wife that you will buy her a pair of shoes every other day or every other month, or you will give her money to make her hair, and then you divorce. So the very moment you divorce, you cease to exist. Can she then take you to court and then say, oh, he gave me a promise, and a promise is a debt? The court says otherwise. A promise is a debt. And this principle was best brought out in the case of Balfour versus Balfour, because this was a couple. That's why they have the two names. Now, Allow me to talk about the law of consideration. Consideration takes the spelling of Consideration. It means an advantage or a benefit moving from one party to the other. It is the essence of a bargain, something in return, like I did say, a give and take. A promise to do something and getting nothing in return is usually not enforceable by law. Consideration need not necessarily be in cash or kind. It may be an act or abstinence or a promise to do or not to do something. And then, of course, there are what they call rules of consideration. And that's what I have been talking about. That in the case of Kuri versus Misa, consideration was defined as something of value, a benefit, or a detriment, or a gain, or a loss. And so when you look at the rules of consideration, which of course is always one of the questions that is asked to students or candidates or scholars who are studying law of contract in consideration, one of them is that consideration, or rather past consideration is no consideration, which means if you do something before negotiating for it, let's imagine you have been employed in a hotel without you having been given a contract, or you have not been told how much you are working for, and you provide a service, you cannot, at the end of having provided the service, ask for the money at law, because you did not negotiate how much to work, rather how much to be paid at the end of the service you provided. So past consideration is no consideration. And the other principle is that consideration must move from one person to another, from one party to another. If consideration does not move, something of value does not move from one person to the other, then there is no consideration, and ultimately there wasn't any contract. I will encourage you to look at the notes that I gave you, to look at the different rules of consideration. But as of now, I have said that consideration means something of value, and something of value is you gain it, meaning you receive it, or you give it, you hand it over. Where that's why I'm using the word forfeit. You hand it over. So if you have if you're providing food, then you're expecting to be paid. If you're providing car hire services, you're expecting to be paid, because the other person received it and is supposed to give you money in turn. Capacities of competence, like I already said, that it's important that the parties that are going into this contract, who have to have a mind that meets, which we call consensus and idem, must have certain characteristics. So the parties to the agreement must be capable of entering into a valid contract. Every person is competent to the contract, or to enter into a contract, if he is of the age of majority. Age of majority in this case means that such a person is above 18 years in the law of contract. But a person who is above 16 years is also considered to be competent in the Employment Act. In other words, a person who appreciates, as a result of their age and experience, that they will benefit or will lose from this negotiation. So it's important that age be of majority. And that particular person is also expected to be of sound mind, meaning they are not mentally incapacitated and is not disqualified from contracting by any law. For instance, a person who has already been declared bankrupt by court or, or insolvent for companies, such a person does not qualify to enter into a contract, which means they are incapable of paying for the service that has been rendered. So, in as far as capacity of the parties is concerned, they must be of age, they must be of sound mind, they must not be intoxicated, meaning they must not have taken anything that takes away their mental ability, and at the same time they must not be mentally disturbed. However, there are what they call exceptions to the capacity of or competence of persons to enter into a contract. And this is in exceptions where, one, that particular service such a person is requesting for will save their life. If it is life-threatening, then such a person is competent to enter into that contract and be provided for those services. A case in point is a patient who, you remember during COVID, these people did not have the means to buy food. So hotels were set aside and government paid. And they were also given medicine because it was an emergency and it was life-threatening. The other exception is a basic need. Basic need, of course, beyond food. There is also health. Rather, there is shelter. There is also clothing. So when those particular services are being provided or are being requested by people who are mentally incapacitated or do not have money, they are broke, or they have been declared bankrupt by court, that is the exception when they can enter or when they can be seen legally to have that capacity. I will, of course, in class expound on it, explain further about it. So, free and genuine consent. It is essential to the creation of every contract that there must be free and genuine consent of the parties. Free and genuine consent. Genuine means nobody has taken unfair advantage over the other. If the other person is illiterate or they are blind or whichever incapacitation, the one entering into the contract and has that unfair advantage is expected to have acted genuinely, or what they call due diligence, in good faith or bona fide. The consent of the parties is said to be free when they are of the same mind on all of the material terms of the contract. There is absent of the free consent if the agreement is induced by coercion. Induced means that it has come as a result of forcing the other person, or they have acted under undue influence, or it has happened as a result of fraud, or it has also happened as a result of misrepresentation. So coercion, undue influence, fraud, misrepresentation, these are also called vitiating factors. Vitiating factors. Vitiating factors. I repeat, vitiating factors, because those are factors that make a would have been good contract become bad at law, because there wasn't consent, that the other party did not intend the contract to happen the way it did, because they were coerced, they were under undue influence, or it was a result of fraud, or they were misrepresented, or they were misunderstood, or the person who they based their decision on did not act in good faith. So those instances would disqualify a contract and it would be done away with. So lawful object, the object must be, the object means the objective for which you are entering into that contract must not be illegal, must not be immoral, it must not also be opposed to public policy. So if an agreement suffers from any legal flaw, it would not be enforceable by law. agreement not declared void. The agreement must not have been expressly declared void by law in force in the country, meaning that there are certain services that are already illegal in Uganda, and if they are provided, then those such contracts are unenforceable. A case in point is human trafficking. If a hotel or a service provider is involved in human trafficking, the law in Uganda bans it, and internationally it is banned. If you are also engaged in what is called money laundering, the law in Uganda bans it. It is an illegal transaction. If you're providing a service in a brothel is a place where prostitution happens. The laws of Uganda punish that. So any such enterprises or any such undertakings, I am not calling them agreements because they are not allowed lawfully, and you cannot enforce them in our country. So in other words, they are illegal transactions or undertakings, and they will affect the contract. So certainty and possibility of performance. It's also important for you to appreciate that whatever services that you're going to provide must be certain, and it's very possible that it will be performed, the absence of which renders that undertaking illegal. So the contract must be certain and not vague or indefinite. If not, if it cannot be enforced. This is important because when you're drafting a contract, you must put in timelines within which the parties are going to be fully discharged of their obligations, the lack of which makes it long and winding and vague and indefinite and becomes unenforceable. So it's important as experts who are ultimately going to be reading or interpreting or enforcing these contractual obligations, it's important for you to also look at time over and above you looking at the illegality, immorality, or opposition to public law. It's also important for you to also look at whether there is a timeline, a time lag, and so in the case of Scamel versus Austin O, agreed to purchase a motor van from S on hire purchase terms. The hire purchase price was to be paid over 2 years. Held there was no contract as the terms were not certain about the rate of interest and mode of payment. No precise meaning could be attributed to the words on hire purchase. Hire purchase, is a vague phrase. So it's important that whoever is drafting it also becomes very definite or very particular. Hire purchase. No precise meaning could be attributed to the words on hire purchase since there was a wide variety of hire purchase terms. So legal formalities, a contract may be made by words spoken or written, which means that a contract you can make a contract either by writing it or by conducting yourselves as having agreed, which means a contract is either in writing or in actions. But there are certain exceptions. For instance, if you are entering into a contract, a sale agreement, which is above 200 shillings, the sale of goods would require you to have that in writing, or it would be only of evidential value when it is in writing. A land transaction would also be required to be in writing. Anything that is done on land must be in writing. So going away from the contract either being spoken as word of mouth or in writing or conduct, there are exceptions as to some contracts that must be in writing. Just like when you come to university, don't you think that ultimately you need to get a certificate, which is a document? Or if, for instance, if you agree to provide services that are above 1 million shillings, wouldn't you think it's important to have that in writing? So the law envisaged that those were important and required that they too be in writing. But then again, if somebody is going to give you a loan, wouldn't you think it's important that it is in writing? Because how then will you tell that that particular person failed to pay, or you agreed on certain interest, or was supposed to have given you something in turn in the event they failed? So it's important to have those terms in writing. So in the interest of the parties, the contract should be in writing, like I have ably said. In the interest of the parties, the contract should be in writing, I emphasize. The document in which the contract is incorporated is to be stamped or signed so that those particular parties can be held to account, or that they do not have, or rather they will be stopped from denying that they entered into those contracts because there is a known handwriting or seal that defines who they are. When there is a statutory requirement that a contract should be made in writing or in the presence of a witness or registered, the required statutory formalities must be complied with. Like I did say already, a marriage agreement, believe you me, must be in writing. And because these spouses must show it at some point. I also said a land agreement should be in writing. I also said that agreements or contracts that are for loans need to be in writing. And any such transactions that are above 200 shillings, it is now mandatory or statutorily required that they are in writing. And whoever enters into those and actually wants to be held to account will definitely know that if they did not have them in writing, they have cheated you. And that, of course, fails having evidential value or burden is imposed then. Contracts accrue to validity. Now, what is a voidable contract? It is important for us to also know that there are certain contracts that are voidable. Voidable means that they were entered into correctly, but now can be avoided. An agreement which is enforceable by law at the option of one or more parties thereto, but is not at the option of the party or parties or others, is a voidable contract. So when the concept of a party to a contract is not free, the contract can be avoided at his option because he did not freely get into it. When a party to a contract promises to perform all obligations within a specified time, any failure on his part to perform his obligations within the fixed time makes the contract voidable at the option of the promisee. Because the other person who was promised is now seeing that one is not living to their promise and the time lag or the time limit has expired. Void contracts. The first statement I was saying, voidable contracts, meaning these are contracts that were valid. Now they are being avoided after having been entered into. Now, there are those contracts that are void agreements. An agreement not enforceable by law is said to be void, meaning it's empty. It was a hoax. A void agreement does not create any legal rights or obligations. Now, void contract, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. A contract, when originally entered into, may be valid and binding on the parties. It may subsequently become void. And that is why we have a clause. We have a clause in all agreements which talks about unenforceability, meaning that there could be instances such as war or government seizes or there is an order, and then the contract cannot in itself survive. And that's an instance, for instance, that was experienced during COVID times. None of those, for instance, you remember during COVID times, government closed all the hotels. So if somebody had already booked for the whole year, you have received their money, and perhaps you have used it to build, you can't enforce the contract. And that is the force majeure. Illegal agreements. An illegal agreement is one which transgresses or which is controversial. So some rule or basic public policy or which is criminal in nature or which is immoral. All illegal agreements are void, but all void agreements are not necessarily illegal. Unenforceable contracts. An unenforceable contract is one which cannot be enforced in court of law because of some technical defect such as absence or writing. If somebody gave you land, if your relative who died gave you land and never put it in writing, you'll find it a challenge. So classifications according to formation. There is what they call express contract. If the terms of the contract expressly agreed upon at the time of the formation of the contract is said to be an express contract. Implied contract. An implied contract is one which is inferred from the acts or conduct of the parties or course of dealings between them, that we have always been doing. I have always been giving you food, whether you have requested me or not, and you have always paid after having received without even my request. So it is inferred that you are to pay. Quasi-contracts. A quasi-contract is not a contract at all. Quasi-contract is not a contract at all. A contract is intentionally entered into by the parties. A quasi-contract is created by law. It resembles a contract in that a legal obligation is imposed on a party who is required to perform it. For instance, T, who is a tradesman, leaves goods at C's house by mistake. C treats the goods as his own. C is bound to pay for the goods, because anybody who leaves anything by mistake, it can't automatically be yours. You ought to have put up a message to find out, or you ought to have announced lost and found. E-commerce contracts, and I must warn you that this is where the world is headed. This is your generation of information and technology and the digital age. E-commerce, electronic commerce. So the contracts which is entered into by the parties via internet is called electronic commerce contract. Of course, you know that somebody can send you, well, you have bought things on Jumia online and paid online, or you have used and then they are delivered. So classification according to performance. It's also important for us to know the different types of contracts as they are being performed. What is an executed contract? And an executed contract means that which is done. If both parties have performed their obligations, they have executed their contractual obligations. So their contract ceases to be existing. They have executed it. Executed contracts, both parties have yet to perform their obligations, so it is present continuous. It may sometimes partly be executed and partly executory. Unilateral contracts, when only one party has to fulfill his obligation at the time of the formation of the contract, the other party having fulfilled his obligation at the time of the contract or before the contract comes into existence. For instance, you come and I ask you for a loan, rather you come and you ask me for a loan, I give you the loan, I've paid my part. So I wait for the time when you are supposed to pay it back. A permits a railway coolie to carry his luggage and place it in his carriage. The contract comes at the end as it is placed in the carriage. Now it is the obligation of A to pay the amount. Then there are also what we call bilateral contracts. The obligation on the part of both of the parties, the contract is outstanding at the time of formation. It's executory. Bilateral, as in the two people have agreed to enter into it. Now, there, it's also important, or I would want to stop here so that we can have opportunity next time to talk about the other parts or issues that will arise from the law of contract. I just wanted you to have a sense of this so that subsequently when we meet, we can have questions, I can give clarifications, but I wanted to give you this so that you can blend it together with the notes I've already given. It's important, now that I wrap up, it's important for you to know what is a contract, that it is a proposal given to a person, a promisee, to accept when the promiser, who is the offerer, gives the promisee, then the promisee is supposed to accept, and in accepting is supposed to communicate. And their understanding is supposed to be enforceable. Enforceable in the sense that it is accepted at law. It is also important that those that get into the agreement are parties that are legally recognized or qualify or competent, and that what they are agreeing on must be legally binding on both of them, and it must have consideration. And it's important that you also appreciate the different elements or characteristics that make up a good contract. So they said, I wish you a good Friday. I would have said I wish you a good night because the time I'm making this movie, it's at night. But I wish you all the best. I remind as Talivita Moses that this is specifically made for the class of 2020 of Hotel and Catering Law. Now that we are in the thematic area of the law on contract. I wish you all the best.